every second, every minute, man, I swear that she can get it. Saying if you a bad bitch, put your hands up high, hands up high, hands up high. Tell them dim the lights down right now, put me in the mood. I'm talking about dark perfume, go.
I recognize your fragrance, hold up, you ain't never gotta say shit, and I know your taste is a little bit, high maintenance, everybody else basic, you live life on an everyday basis, with poetic justice, if I told you that a flower bloomed in a dark room, would you trust it? I mean, I write poems in these songs, dedicated to you, and you're in the mood for empathy, there's blood in my pen, better yet with your friends and them, I really wanna know you all, I really wanna show you off. Pour up plenty of champagne. Cold nights when you curse this name. You called up your girlfriends and your girl in that little bitty range. I heard that she wanna go and party. She wanna go and party. Nigga don't approach her with that Atari. Nigga that ain't good game home is sorry. They say conversation rule the nation. I can tell, but I could never right my wrongs unless I write it down for real. P.S. You can get it, you can get it, you can get it.
I'm so anxious just to feel the silence. It's so quiet, but I hear you. Say it to me, baby. Say my time, we're making enough time. The times you wasn't really waking up. Now you never say I couldn't miss your touch. I need you, I need you. Need to distance myself from you. I was just in love with you. So confused with you. Won't you? Can I tell you something for what it's worth? We've been having a bad time. Take you, take you. Show you something, give me more than words. We've been having a bad time. Take you, please be done. Please be done. Give me that. I want you to give to me. Yeah. Please be done. Please be done. I want you to give to me.
Every second, every minute, man, I swear that she can get it. Say if you a bad bitch, put your hands up high. Hands up high. Hands up high. Tell them dim the lights down right now. Put me in the mood. I'm talking about dark room, perfume. Go, go.
I recognize your fragrance. Hold up, you ain't never gotta say shit. And I know your taste is a little bit high maintenance. Everybody else basic. You live life on an everyday basis with poetic justice. Poetic justice. If I told you that a flower bloomed in a dark room, would you trust it? I mean, I write poems in these songs dedicated to you when you're in the mood for empathy. There's blood in my pen. Better yet, with your friends and them. I really wanna know you all. I really wanna show you off. Fuck God, pour up plenty of champagne. Cold nights when you curse this name. You called up your girlfriends and y'all curled in that little bitty range. I heard that she wanna go and party. She wanna go and party. Nigga, don't approach her with that Atari. Nigga, that ain't good game, homie. Sorry, they say conversation rule the nation. I can tell, but I could never right my wrongs unless I write it down for real. P.S. You can get it, you can get it, you can get it.
A verdict out of the state of Georgia in the case against Trinity Pogue. You can see, Michael, 2 hours, 56 minutes. They had a question. Now we understand they have a verdict.
Yeah, we see that from time to time when jurors have a question. It doesn't take too long after that for them to resolve any issues that they had. Again, Trinity Pogue charged with murder in the death of the son of her then boyfriend who had been staying at her dorm room. He had left her in the room with the baby. The baby ended up with some very serious injuries. So the supposition is that she caused those injuries, but of course the defense is claiming she did not, and perhaps they were caused by someone else or at some other time. Let's bring back in our guest still with us, criminal defense attorney Forrest Miller. Forrest, as I said, a lot of times you get these questions. This is a little quick, but a lot of times you get these questions, and then the jury sort of clarifies what's going on in there, and then they come out with a verdict.
Yeah, I'm surprised that it came so quickly after. We were waiting for maybe 20 more minutes. That's great. They got their stuff clarified. That was obviously holding them up from their verdict. They defined some things, and they pulled the trigger. So I'm excited to see what the verdict is.
I was surprised it was that quick as well. And we do want to mention that is a live picture of the defendant. They're the judges. He just took the bench. We do not have any audio yet. We're waiting for the jury to get back in there. And I have to just comment on her demeanor. She's been a little bit like that. We see her now. I would be worried. I think 3 hours in, if it were me, I would be worried. Forrest, tell us what you think. And if we cut you off, it's only because they've started court.
Sure, understood. Yes, I I think it's my opinion that when verdicts come quickly like this, that it's most often bad news. So her demeanor is appropriate. I think that she has some bad news coming down the pike right now.
Forrest, she didn't take the stand in her own defense. Do you think that was a mistake? I certainly do.
She can't really explain too much. They found the body in her room, and maybe to her personally, maybe she wants to hold that close and not really divulge the information that she has, and it's her prerogative. But I really don't think she could have talked her way out of this.
All right.
I think.
What person does the
Yep, we have audio. Let's go in.
All right, if you would pass that to my bailiff, please. All right, Ms. Pogue, if you would please stand. The verdict reads as follows, as to each count. On count one, it says, we, the jury, find the defendant not guilty. On counts 2, 3, 4, 5, and 6, the verdict reads, we, the jury, find the defendant guilty of felony murder, 2 counts, aggravated battery, 2 counts, and cruelty to child in the 1st degree. Y'all can have a seat. Ladies and gentlemen, it's been a tough week for you, I'm sure, and I know that you probably had a lot of places you would have rather been this week than here. I do want to thank you tremendously for your service. You have shown up, you've been on time, and you've paid thorough attention. You've taken in a lot of information this week, and you obviously, from the fact that you've deliberated over this, you've looked at this very closely. So with that, your county appreciates the work you've done, and you'll receive a stipend. It's just a token of the county's appreciation. You are free to leave for the term. You're also free to, you can certainly step back into the courtroom through the other door if you wish to, or hang around if you want to speak with the lawyers, but you don't have to. You don't have to talk to anybody. You're welcome to leave at this time if you prefer. If you do, turn in your badges on your way out, and make sure that your notes are in the jury room. And I really appreciate it. Y'all are free to go.
The jury is free to go. We're waiting to see what the judge does next. Her explosive reaction to the not guilty on malice murder, meaning no intent. But
was there anything we hold the jury for just a second? Ask them to step into the jury room. No, ask them to step into the jury room. Ask them to just step into the jury room. Yeah. Jed, if you'll pass this down, please pass this down to the lawyers.
All right, well, they're just figuring that out. We can go back in when he starts to speak with the lawyers, but I just want to mention all the lesser charges has the same potential sentence, Michael, as malice murder. The judge will decide whether it's life without parole or life with the possibility of parole, even on these lessers of felony murder.
Yes, I was a little surprised at how happy the family was at the malice murder being not guilty, because basically, like you said, they carry the same penalties. So she's really not out of the woods. But I want to say the cruelty to children charge, which she was also found guilty of, that's one sentence that can be added consecutive to whatever the judge finds. I think I hear the judge again.
Mr. Campbell?
Yeah, John.
All right. All right, my proposal would be to let's proceed with sentencing. I would like to give you all about 15 minutes and come back in and I'll hear from both sides, and then I'll pass sentence. So it's 4:35. I'll be back in at 10 minutes until 5, and go ahead and hear from both parties and conduct sentencing. Thank y'all.
All right, so you heard the judge there. They're actually going to do sentencing today.
Yeah.
They're going to take a quick 15-minute break. The attorneys will then make their arguments to the judge, and the judge ultimately will make that decision whether she gets life in prison with parole or life without parole. And I think that might be on the table. Not sure it's on there for felony murder or not, but I think certainly life with parole or life without parole will be on the table.
I think death is on the table too. Under the sentencing guidelines, right? That's a possibility.
Right.
I just have to mention that now that the defense just found out what she's been found guilty of, not malice murder, I'm a little surprised they don't want to think about sentencing to determine what witnesses, if any, they want to present. But that's not what's going to happen.
That's not what's going to happen. Welcome back to Court TV Live. I'm Michael Ayala.
And I'm Judge Ashley Wilcott. Just moments ago, a jury returned a verdict in the pageant queen child murder trial in Georgia.
The verdict reads as follows, as to each count. On count 1, it says, we, the jury, find the defendant not guilty. On counts 2, 3, 4, 5, and 6, The verdict reads, we, the jury, find the defendant guilty of felony murder, 2 counts, aggravated battery, 2 counts, and cruelty to child in the 1st degree.
They just heard it. After nearly 3 hours of deliberations, the jury did find Trinity Pogue not guilty of the top count of malice murder, but they found her guilty on the other 5 counts, including felony murder and the death of 18-month-old J.D. Williams.
And she had a very, as you saw, visible reaction. Well, right now, the sentencing phase is underway. Let's get inside that court.
All right, we're going to address sentencing. Before we do that, I want to see if there's any disagreement as to merger of the charges or vacating any of the sentences because of the I know that the aggravated battery charges merge with the felony murder charges, and I believe the cruelty to child does as well. But I want to see what both parties indicate.
No, sir, I don't think they agree.
Okay, what is your position on that?
The state's position is that, of course, the court could impose sentence on. Did you go straight down the line? The court could impose sentence on count 2, which is felony murder. Count 3, felony murder, would be vacated because you can't be sentenced for 2 murders in the same case when there's only 1 victim. Count 4, aggravated battery, would merge with count 2, felony murder. Count 5, aggravated battery, would stand alone because you would only merge 1 felony with the felony murder, not 2. Even though the felony murder, because the felony murder is. Well,
can I see the indictment? Will you give me the indictment from the?
I mean, I have a copy of it. I don't know. I guess
it's with the exhibits.
Is it in that?
Well, if you have a copy, that would be just as well.
I just counted all the exhibits. I didn't even think about that.
I don't know.
You can hand it up. That's fine, Laura.
I do have a copy. Right. So
let the court reporter sit up there.
Yes, sir. Yeah, please.
All right, let me ask you this question. Felony murder in count 2 charges her with murder based upon the commission of aggravated battery by causing blunt force trauma to the head and torso, right?
Yes, sir. But that "and" is interpreted disjunctively. And I mean,
let me finish my thought pattern,
yes,
and then
sir.
you can tell me your response to that.
Okay.
Count 4 charges her with aggravated battery by rendering his brain useless, and count 5 by rendering his liver useless. And then count 2, felony murder, charges him with aggravated battery for both of them. I mean, in either way, right? To the head or the torso. So why wouldn't both merge into count 2?
But first of all, with respect
Can we
to
take a break? Are you looking for the indictment?
Yes, sir.
Okay. If it's not in there, then they need to hold everything in there. Okay. All right. All right. Okay. You can go ahead.
So even though which count is the count 2 is the one that relates to the aggravated battery?
Yes.
Right?
Yes.
Okay. And so it refers to an aggravated battery based on damage or to the brain and to the liver. That
and torso.
Or head and torso, right? That "and" is should be interpreted disjunctively. In other words, if there was a finding that only a battery to the head, that would be sufficient to support a claim. I mean, a finding of guilty on felony murder. If there was a finding of aggravated battery only on the torso, that would be sufficient to support it. So since either of them will support the felony murder, only one of them merges. And then count.
How do I know which one merges?
First one. If you go straight down the list of charges, okay, and you get count 3 is vacated, count 4, merge with count 2, and then now there has been a merger for count 2, which means count 5 would not merge; it's left freestanding, and count 6 can't merge because count 3 was vacated. So the sentence should be on felony murder and on count 5 aggravated battery and count 6 cruelty to children. That is the state's position.
All right, Mr. Gamble.
Yeah, we disagree on that interpretation. I believe that the court is correct concerning the merger of the aggravated battery. That's the only charge that should stand in the first count of felony murder, which is number 2. And then the others would have merged in one way or another and be out. And then the only other charge could be cruelty to children. I believe would be the only one that remained with the felony murder. That's our position.
Do you happen to have any case law that addresses this particular situation?
Yes, sir. I mean, if the court wishes to take it.
Maybe we should take a recess.
Well,
I
I'm looking right now, Judge.
Okay. And I mean, you do agree that then the felony murder, the 2 felony murders, 1 vacates, right?
Yes, sir. Count 3 is vacated. That's correct.
But the fact that count 6 would have merged with count 3 doesn't affect count
No,
3.
sir. Once it's vacated, then there is nothing for it to merge with.
Okay. So the question is, and I think Mr. Gamble agreed with that, the question is whether count 4 and 5 merge with count 2, because the felony murder charge in count 2 included both, whether it's, I guess it says and, you say that says is the disjunctive, which means or,
Right.
but it includes count 4 or 5 or 4 and 5. I mean, they could have found her guilty of both. Well, they did. They did find her guilty of both. So I guess I need case law on that. If the state is seeking a sentence on aggravated battery count 5. So we'll take 30 minutes. Mel, you come with me, and we'll take. I'll give you some. I'll alert you when I'm ready to address that.
All right, so what's at stake here? The judge, as he tries to decide whether he's going to sentence on that aggravated battery, that 1 remaining charge, and the cruelty to children. Well, that remaining aggravated battery charge carries 1 to 20 years.
Right.
And the cruelty to children carries 5 to 20. And again, the judge has to decide, does that aggravated battery merge into that felony murder, both of them, or does one of them survive? And while they take that recess to try to figure it out, they're going to get some case law and make their arguments. Let's bring in our guest, criminal defense attorney, former assistant prosecutor, Franz Bogart. Franz, great to see you. I am sure you've been in this position before. This comes up very often in these types of circumstances. Love to get your thoughts on it.
So if I'm defending her, I want to hit the brakes. I'm going to say to the judge, I want an opportunity to brief this. I want an opportunity for a full sentencing hearing to present mitigation. And I understand there's some places in the world, in the United States, where sentencing happens immediately after conviction. Defending her, I want to hit the brakes. If I'm the prosecutor and I'm trying to max out her time, I might want time to actually brief this issue to show the judge that, look, yes, we threw a whole bunch of eggs into the basket of the indictment, but just because they convicted her of these things doesn't mean you lose the ability to enhance her sentence. And look, this whole entire conversation is about jail time. How much jail time is she going to get? How much jail time has she done? How much is she going to get? And what is the discretion the judge may or may not have with a mandatory minimum? So either side, I want to hit the brakes and I want more time to inform the court.
You know what's interesting, Franz? The one reason I think if I were defense right now that I wouldn't hit the brakes is because the judge came out of the chutes doing what they want, which is saying they merge, it's felony murder, the aggravated cruelty to children. And now the judge is saying, is there any case law? So I think I'd see, is the judge still going to come down on my side? And if he is, then we don't need more time. But if he's not, then I'm going to say, wait, judge, let's brief it. That's just my thought process. But part of this to me also, and I want you to weigh in as a defense attorney, Franz, it's not just the number of years and sentences. It's also if there's an appeal, it's appealing 2 charges or 3 charges. And I would think that could be a significant difference.
So there's the appellate issues, and that's a big deal. That is a very big deal, especially if we're talking about different mandatory minimums. In Louisiana, you don't get this kitchen sink of she gets convicted of multiple types of murder, and then we just kind of figure out afterwards. It's one. She gets one. And generally with felony murder, in a lot of jurisdictions, you don't get convicted of the underlying felony and the murder. So there is that weird appellate issue that she has. And look, she's maintained her innocence. So it's not like she can stand up, judge, and all of a sudden take responsibility, because at that point, what is she doing? The other side of this, though, is, and I understand it sure does look like the judge is leaning towards the defense, but that can change in a heartbeat. And man, oh man, would I want an opportunity to present some mitigation on her behalf.
That I agree with. And he set this sentencing. And to me, I guess I assumed they're not going to be witnesses because it is in local time, 5 p.m. That on a Friday. And I would agree. And I'm surprised, Michael, that they didn't want to take the opportunity to present mitigating evidence.
Yeah, and again, I have to reiterate what's at stake here. If there are 2 additional charges, Franz, that she can be sentenced on, if he sentences her to 25 to life with possibility of parole, but she has consecutive sentences for, let's say, aggravated battery of another 10, because it was a very ugly and serious battery on a child in her care, and the cruelty to children, 5 to 20, let's say he hits her at 10 there, now she's looking at being in jail for 40 years before she's available for parole. So I think this is very serious stuff for her.
So on the one hand, if you're the defense team, you're thinking to yourself, we just won this trial because she's not been convicted of the most serious count, right? On the other hand, On the other hand, you're thinking and arguing everything should be run concurrent. This was one transaction. As horrible as it was, this was one act, one transaction, and you shouldn't piecemeal give consecutive time. That's the argument. Now, I'm not saying that that is going to prevail in this case, Michael. I'm just saying that's the toolbox from the defense attorney. He or she is pulling out this should all be run concurrent. That said, I go back to what Judge was kind of intimating, which was, well, maybe he's leaning towards not giving her this big giant sentence and trying to give her, she's a young defendant. She probably doesn't have any kind of a criminal record. This is one where, as brutal as a murder as this was, there are mitigators to be argued, to be sure. And so, yeah, high stakes poker table right now. I'm sticking to my guns, though, guys. I would want time to put on a show, so to for sentencing, to put her in the best position to give this judge the tools to give her a better, quote unquote, sentence.
Yeah, fair enough. And I will say this, according to the law in Georgia, the only one really that's allowed to be put on consecutively, if it's not included in, is the cruelty to children.
Exactly.
He
Otherwise,
has the
it's
option.
concurrent.
He can sentence that separately, or it can be rolled in as a concurrent.
And those two stand. I don't think anyone disagrees. The felony murder, the aggravated cruelty to children, those two we know
Absolutely.
she'll be sentenced on. So what we're going to do is take a break. When we come back, we'll bring you more. We're going to continue to monitor the courtroom as we wait, because it gave a break for them to look at some law. And when it begins, we'll take you back to the pageant queen child murder trial sentencing of Trinity Pogue.
But up next, we're going to turn back to Massachusetts to pick up testimony in the disappearance of Anna Walsh trial. So keep it here on your front row seat to justice.
Disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight, on closing arguments, a murder on a cruise ship and a custody dispute involving a suspected teenage killer. Bringing the latest surrounding the death of Anna Kettner.
Closing arguments tonight at 8, 7 Central, only on Court TV.
We want to head to Massachusetts in just a moment. But first, the court in Georgia is on a break to review case law ahead of sentencing for Trinity Pogue. Now, the jury found her not guilty of the top count of malice murder, but found her guilty of all other charges. This includes 2 counts of felony murder, 2 counts of aggravated battery, and 1 count of aggravated cruelty to children. When they come back into that courtroom, we will bring you that sentencing.
Yes, we will. But right now, we want to bring you testimony in the disappearance of Anna Walsh trial. Her husband, Brian Walsh, has pleaded guilty to charges of misleading police and improper conveyance of a body. Well, now a jury must decide if he's also guilty of killing his wife.
Anna was last seen on New Year's Eve in 2022 and was then reported missing by her company a few days later.
The state has focused on evidence about the defendant's Google searches, which included how long before a body starts to smell, and can you be charged with murder without a body?
Let's head back to court now. The digital forensic examiner continues to testify, cross-examination by the defense.
And those searches continue through 12:45:58 on page 4, don't they?
All right, as we brought you just moments ago, the verdict in the pageant queen child murder trial for Trinity Pogue, the judge had sent the attorneys out to do some research regarding an issue regarding sentencing. My understanding is that they are now back in the courtroom, so we want to take you there live.
All right, I'm being told that the state and the defense agree that the sentence that the court is going to impose is for counts 2 and count 6.
Yes, sir. I advise Mr. Gamble that after doing some additional research, or some initial research rather, on that particular question, I think that 4 and 5 would merge with count 2. And that being the case, the state's position is the court should sentence on count 2 and count 6, which I understand is the defense position as well.
Correct.
Yes.
Yeah, that's what I was finding too. I had never seen a case where you could back a charge out of the felony murder, even if it was. Of course, in very few cases where more than one felony are charged in a single count of felony murder. But at any rate, then count 3 will merge. Will be vacated. Count 4 and 5 will merge with count 2, and count 6 is a standalone offense based upon the merger of count 3. The vacation, the fact that count 3 had to be vacated. Is that correct?
Yes, sir.
All right. I'll hear from the state concerning sentencing as to count 2 and count 6. And of course, if you want to present any witnesses, you certainly can. And I believe the sentence possibilities are life on count 2 or life without parole. And on cruelty to children, the first degree, the sentencing range is 1 to
5 to 20.
5 to 20. Okay. All right. All right. I'll hear from the state first.
United States proposes that the appropriate sentence in this case would be a sentence of life in prison on count 2 with a sentence of 20 years consecutive on count 6. I understand that Ms. Pogue is very young. I think this is the terrible tragedy of these kinds of cases. I have a baby as a victim and who was at the time a teenager as the defendant, and I think that the jury's verdict. It's not always very possible to get an interpretation of what the jury might have been thinking. But I think if you look at the way the verdict is structured, that it suggests to me, at least, that by finding a not guilty on malice murder, that there was a belief that there was not evidence of a specific, essentially a specific intent to kill or a deliberate intention to kill, and that would be the distinction between count 1 and the remaining counts. And so, in my view, if I accept that as a finding of fact, from my perspective in proposing a sentence, if I consider that or accept that as a finding of fact of sorts, that there's evidence of malice, and there's evidence of conscious disregard for the consequences of her actions, then I feel justified in asking for consecutive time. But if I do not believe that the evidence supported this jury in making a finding of a deliberate intention to kill, such as would support a malice murder conviction, then I'd feel constrained to leave the recommendation at life without parole. Life in prison as opposed to life without parole.
All right. Do you wish to present anything? Anybody wish to say anything from the family, or are you presenting any testimony? No,
not presenting any testimony, and I'm not the father of the child is not father and are here, of course, but I'm not asking them to make statements to the court, and I've told them both that they could if they wanted to do so, but we're not going to.
Okay. Mr. Gamble?
We recognize felony murder. I don't think if they're recommending life with parole, that's as lenient as the sentence could be under that particular charge. I don't think you can go below life in prison for a felony murder charge.
Right.
So we don't dispute that. We would ask, though, Your Honor, the cruelty to children, they're asking for consecutive 20 years. If you put that on there, you're coming very close to being life without parole, in that you will not come up for parole currently for 30 years and then add 20 more to it. Would be very close to her entire lifetime. And we would ask the court to consider, you've heard the evidence and you know generally what the whole circumstances were. She was 18 years old at the time, a young girl that had not had any trouble with the law, any problems, and was doing well. Now, obviously, she's accused of a horrendous crime that we fought about in court, but we accept the jury has made a verdict, whether I agree with it or not. So she has to now face what the consequences are of that. But it should not be so severe that it would be akin to life without parole. And that would be what happens if you made this consecutive serving time sentence. So we would ask that on the cruelty to children, that it run concurrent with the life sentence that she is going to be imposed on her for the felony murder. So felony murder plus 20 years, but run concurrent with the felony murder charge. Yeah.
All right, so there you heard the defense's argument. They're hoping that he brings that other charge and runs it concurrent rather than consecutive. Huge difference there.
A very big difference.
Yeah.
And I don't know what this judge is going to do. He pointed out, Judge, you heard the evidence, 18, no prior history.
Yeah, what does he think justice is for JD?
Yeah.
All right, we'll pause it right there. When we come back, the judge will be issuing his sentencing. Here right here on your front row seat to justice.
Welcome back to Court TV Live. I'm Judge Ashley Wilcox.
And I'm Michael Ayala. We are bringing you live covering the sentencing days of a child trial going on in Georgia. In a split verdict, the jury found her not guilty of malice murder or intentional murder, but guilty on the remaining 5 counts, including felony murder.
Let's get you back into court now. The judge is ready to issue a sentence. Very short arguments by counsel. He's going to tell us what his decision is.
All right, Ms. Pogue, if you'll stand up, please. I don't do a lot of speaking when I'm passing the sentence. I've heard the case and I've considered the tragedy on the left side, on my left side, and on the right side, and there's a lot of tragedy to go around here. The whole time that I'm hearing a case, I think about what the appropriate sentence would be. And this conduct all led, in my opinion, to the offense of felony murder, even the charge that would have merged with count 3, but does not because count 3 is vacated by count 2. That's a lot of technical jargon. But the bottom line is you're going to receive a sentence of life in prison, which is the appropriate sentence for the conduct that you have been convicted of. And that is going to essentially be the sentence that the court passes in this case. You will be sent on. So on count 2, I sentenced the defendant to serve life in prison. And on count 6, I sentenced the defendant to serve 20 years in the state penitentiary. Those sentences will run concurrent. I do wish to advise you, Ms. Pogue, that you have 30 days to appeal. You also have 4 years within which you could seek habeas corpus. I hope this can bring some closure to the family. It's just a complete tragedy. And I hope that you can, in your older days, have some sort of life after serving this sentence, and life while you're in prison. You just have to make the best of it. But that's the sentence of the court. Wish everybody the best.
All right, Michael. So he just decided it's life in prison, possibility of parole after 30 years. She'll be 48, 49 at that time. Mm-hmm. And these are going to run concurrent. We talked about that. Mm-hmm. What do you think?
I was surprised. I thought this type of crime, the fact that it was a helpless child within her care, that it warranted the consecutive sentence. Mm-hmm. But he said, I listened to the evidence. He's ultimately the judge, and he made this decision. I'm okay with it. 30 years behind bars is a very, very long time.
Murder of little JD, his legal name Romeo Angeles. Here to talk about that guilty verdict and the aftermath, let's bring in our very special guest this morning. The lead prosecutor on the case is with us, Louis Bud Lamb. Good morning to you, Bud. Thank you so much for being on the program, and congratulations on the win. You were excellent in the courtroom.
Thank you. Glad to be here.
Well, we appreciate you. Take us kind of behind the scenes, if you would, please. We know what happened through the trial because we watched every. It was gripping. And not an easy case for you either. There are always some things that can't come into evidence that you know about or theorize about that the jury just can't. Would you kind of take us behind the scenes into some of that information that had to be excluded, please, Bud?
Well, there was a lot of information concerning Ms. Pogue that did not that didn't come into evidence that we had available, I suppose, and some of it was things that I don't know would necessarily have been admissible. A lot of it was stuff that we chose not to use. I had 2 long interviews with her that she had done with the GBI, and I chose not to put those in unless she testified. I was, I guess, like every prosecutor, sort of hoping that she would testify because I wanted to. I had a lot to cover on cross-examination. I'll say it that way.
Oh yeah, tell us.
She gave probably 5 different stories at one time or another. Her final, sort of the final version of her alibi, I guess, was that the child rolled off of the air mattress sometime, and then later that night fell off of the bed, and then the next morning fell off of the chair. So every possible, hypothesis that she had offered at any time, she blended them all together ultimately into a single story. What she never did was point any fingers at the father of the child. I mean, he wasn't involved in any way in the injuries to the child, accidentally or otherwise. And I think that she knew that because of the timing of it, that there was no way that she was going to be able to successfully do that, and so she didn't attempt to.
Interesting. Let's unpack that a little further, please, Bud, because we saw her defense team hint at the baby's father being the problem, and then once he got on the stand and you were able to unpack everything with him, we could see that he was trying the best he could. Was it perfect? No, but he was trying. How carefully did you vet him initially when you first got the case, first look, just to make sure that you had the right defendant?
Well, I mean, I'll tell you, as I said during the trial, he sat through the first 8 hours after he found out that the child had died. He spent 4 of the next 8 hours being interviewed by the GBI and sitting in a police station in between. He went straight from the hospital to the police station, which is where he remained until after 1 o'clock in the morning. They went after him as hard as they went after her in the initial round of interviews. But of course, he was insistent that he wasn't there, and that he had left, and that everything was okay when he left. And then, as they started seeing these, there were lots of videos and photographs, pictures that had been taken that night at one time or another. There was, of course, all of which. Let me back up. All of which showed the child in good health, without any bruising, without any marks on his face, without any without any symptoms of any type of injury whatsoever. So I don't think there was ever really a question as to whether or not he had or could have done something to the child in advance of the time frame that we contended the injuries occurred in. I mean, there was nothing at all that would indicate that was even a possibility. Then, of course, with a video from Georgia Southwestern, we were able to confirm that he, in fact, had done exactly what he said he did. I mean, what time he left, what time he got back, his actions after getting back. And so ultimately, it became clear that he was not involved at all.
Right.
Which left only one person.
Right. You got the right defendant. That's for sure. But let's talk a little bit more about how she may have killed baby JD. Your theory as to what exactly she did in that dorm room.
Well, I mean, I don't think we'll ever know exactly what happened, but I mean, what I think happened, and what makes the most sense in light of all of the evidence that we had, is that this child was crying, this child was upset once the father had left, that she couldn't get him to be quiet, that she, I can't tell you that she slapped him, that she did whatever, but there was a mark on his face, as the medical examiner testified, that was fresh, that was very compatible with either this kind of a grip that was so hard that it left a bruise here, or a slap across the face, and then the injury at the base of the skull. There were other bruises on the head, and there was also internal injuries in the abdomen. His liver was lacerated, his adrenal gland was lacerated. There was bleeding around his lungs and around his ribs, and I think that throwing the child against something, picking him up, the medical examiner hypothesized that he might have been picked up, by his shoulders like this and slammed down really hard against a desk, against a bed. And there's no way to know what object was used because there weren't any external injuries. So there was no bleeding. There was nothing that anybody could see with their eyes.
Sure.
But I think that's what happened. She just simply lost it. I mean, she didn't like the child, and for whatever reason, she didn't like the child. She had made that clear. And I think that when somebody doesn't like a kid, it becomes very easy to lose your patience. And I think that's exactly what happened. She just lost it, and once she flipped out, there was no. There was nothing sane about the approach, about the injuries that were the process she went through.
No, just awful. Well, this was a tough case to try. It's really hard to try a baby death case. It's awful. It really takes special people to do it, and you are one of those very special people. Prosecuting Attorney Lewis Bud Lamb, thank you so much for your time this morning. We'd love to have you back on Court TV. Maybe you'll come on and analyze another case for us when there's no pressure. You're not in the courtroom, not trying the case. We'll just have you on to look at another one. That'd be great. Thank you so much.
Be happy to do it. Thank you. Take care. Goodbye.
Coming up next for you here on Opening Statements, here's what we've got.
Was she given the option of staying in another room?
All three of the kids were.
Okay. And would that room have been with Grandma and Grandpa?
Correct.
And they didn't want to do that?
No, they wanted to stay together.
All right, y'all, that's gonna be it. That's pretty much it. I pretty much wanted to cover the verdict and cover the sentencing, and that's it. That's pretty much it on that. I will say I'm like keep it cute. I think that she should have been found guilty of malice murder. I think for some reason I don't know. I kind of felt like I'm not gonna say that she planned to unalive the baby. I'm not gonna say that. I'm not sure about that, but I am sure that whenever she was doing what she was doing to the baby, she intended on harming him. Because the type of injuries that he sustained, you don't You don't get those type of injuries without some type of intention, like force or beating. You know what I'm saying? I don't listen. I look at that woman and I see evil. I mean, I just do. I look at her and I see in the words that she takes to her friends, the things that she was saying, even to him, which I don't understand. Like Cuba was saying yesterday, there were so many red flags, so many. When somebody is able to voice to you or text to you or write to you those words that she wrote to him when it came to his child, you got to get far away from a person like you. Even if you want to deal with that person, you never ever ever leave that person alone with your child. And me myself, I'm not gonna deal with a person that I feel like, you know what I'm saying, can't be around my child. So it just would have been a done deal for me. But you know, I will say though, when it comes to men, they don't get it. I do feel bad for that young man though. I honestly do. I feel so bad for him. I feel bad for the baby, but I mean, you don't want to blame a parent when they because it's a clip in that last portion that I played. That lady, the woman that did the interview with the lawyer, she made a statement that I couldn't believe she made it, but she did. And the statement was, I didn't play that part though, but the statement that she made was, everybody failed, and she specifically said the mom, who I honestly do believe she absolutely did, and the dad too as well. And if you think about it in a logical sense, he kind of did, but I don't think he intended to. Like I honestly don't think that he felt like that woman would have unalived his child, even though huh, she made it very clear to him and others that how do you not like a child? Even alone right there for me. How do you not like a baby? A baby who has done no wrong, a baby that in any circumstance is not at fault at all. The baby, it wasn't his fault he was born in the circumstances that he was born in. It's not his fault that he's here and you want to be with the dad and you want all the attention with your entitled ass. Because it seems as though this little ex-pageant queen has this whole entitlement thing about her. I mean, you can look at her and tell that and you can go by the words that she said or typed to him, that she felt some type of entitlement. And my thing is this is why I have absolutely no, and I mean no, empathy or anything when it comes to her, because you entered into that relationship knowing that baby was a part of it. I don't know in what world you live in. Oh, this world, because there are some men actually that will put a woman or a chick in before their child, but he was not it. He was not it, and that's what you thought. That woman felt like he should have put her before his child. And when he didn't, she did what she did. And she intended to do it. That's how I feel. Yeah, she was young. But you being young and you saying that you don't know if you can deal with being a stepmom at your age and this and that and the third, bitch, you should have walked away. You should have walked the fuck away. And I'm sorry. Shit. That was my first time hearing that I actually thought she should have gotten life without parole. Fuck that. Like, honestly, she should stay in jail for life. I'm sorry. She should stay in prison for life. That is just ridiculous. I mean, when you take a life, it's bad enough. But when you take a life of an innocent baby with your you got to be evil. Baby, to hit a baby hard enough to cause a brain injury and to cause liver lacerations, you have to be one evil bitch. This is how I feel about it. Anywho, unless Cuba Q want to come up here and say something, I don't know if you busy or not, but if not, we're gonna end this because that's all I wanted to cover. I wanted to cover the verdict in the sentencing, and I'm just pretty much done. Like, thank God that justice was served. That baby's gone. That baby, coming into this world had a lot it was a lot from Gate when it came to him. And maybe God decided he needed to come on home because it was just too much. These demons here on earth was just not capable of you know, I don't know. I can't ever make sense of stuff like this, but I just didn't know. Well, yes, I did. That you could feel some type of the content that I feel for that woman, and she's a person that I've never met. But just knowing what she did to that baby is enough for me. But anywho, I'm gonna get out of here, y'all. You know what I mean? Okay, keep it cute, no problem. No problem at all. I accomplished what I want to accomplish. So yeah, I'm gonna get off of here. We'll be back in about 45 minutes. For the Alan Walsh case. Is it Alan? Why I want to say Alan Walsh? Is that his name? Brian. I think I'm thinking about the guy from America's Most Wanted. I think that's his name. But anywho, the Brian Walsh case, y'all know what I mean. Yeah, we're gonna continue to cover that. Not tomorrow morning before court starts with this Brian Walsh case. I'll be talking about something else. Just so I can stay current with my content, even though we're covering this trial, because this trial looks like gonna last for, I think Trey said 2 more weeks. That's a long trial. But anywho, like I said, I appreciate y'all joining, supporting. I'll see y'all in about 45 minutes. All right. I hope everybody's morning is going okay. Hope everybody doing good. I know it's cold. It's cold here. We woke up to frost on the ground, so y'all know I love the cold weather, so it don't bother me none. I am good. But anywho, I'll see y'all in about 45 minutes. I appreciate y'all. Y'all have a blessed, beautiful day. And yeah, until next time, truth seekers stand up. And we out. Y'all be good.